Good afternoon and welcome to the final session of Ducks in a Row. Today we'll be talking about estate planning. I'd like to begin with a land acknowledgement. People's Memorial Association would like to acknowledge the traditional, ancestral, unceded territory of the Coast Salish, Duwamish, and Suquamish nations on which we work and live. Just a couple standard housekeeping items that I'm sure you're more than familiar with. We're going to go ahead and keep all of our participants on mute today, though I hope that doesn't discourage you from being an active participant. Please feel free to use the chat box or the Q&A feature and share any questions that you might have. We know there's going to be just a ton of information today, so if you're going to need some time to think about what your questions are, we're going to make sure that you have the contact information for our presenter today, as well as ours at PMA. And gosh, let me think what else. Well, yeah, I just let you know, ask your questions. That's what we're here for. I want to make sure that no one's wandering away with a lot of lingering questions. If this is your first time joining us, welcome. My name's Beverly and I'm the Communications Manager for People's Memorial Association. We are the oldest and largest memorial society in the US. We were actually founded right here in Seattle back in 1939. We provide funeral education and consumer advocacy services to all Washingtonians. To date, over 218,000 folks have become members, and of those, about 71,000 of them are still living, so we stay incredibly busy in the office, as you might imagine. When we think about what we do to support those folks, well, one of the biggest things is education. We offer community classes like this and host an incredible diversity of resources on our website and our Facebook and our Instagram. And hopefully one of these days I can talk some funeral directors into learning some choreography, and then we'll branch out to TikTok as well. In addition to our educational resources, we're also really proud of the advocacy work we're able to do here to support our state level legislature in increasing funeral choice, increasing price transparency in a notoriously opaque industry, the funeral industry, and also working to protect cultural rights. We have just a really wonderful diversity of folks here in Washington, and they all have different religious and cultural and racial and important community-based practices relating to death care. And we think all of those, we know that all of those folks deserve equal access to affordable cremation, burial, aquamation, natural organic reduction, and then all of those spiritual and religious practices that go into the mourning and celebration process when someone that they love dies. There aren't any upcoming sessions this year for our programming. This is the last one in the series. If you missed any of the previous sessions in this Ducks in a Row series, you can go ahead and view those on our website or on our YouTube. So please feel free to reach out if you have any trouble tracking those down. We don't want you to miss out on our funeral options presentation or our advanced directives for healthcare. Very essential information on there for you. We'll be back in 2023 with new programming though. Enough about us. I'd love to turn it over to our host from the Seattle Public Library, Emily. It's such a pleasure to see you again.
Yes, thank you, Beverly. I just want to thank, sorry, 1 second. I just wanted to thank everyone that is here today and welcome. I'm Emily. I'm their older adult program manager here at the Seattle Public Library, and I help to run programs for the 50+ audience and advise the library on how best to be age-friendly and more inclusive for all. If you ever have any suggestions on programming, comments, or feedback, we're going to be sending a survey out at the end of this program, or I do encourage you to always reach out to us. We love to hear from you guys. Just a few exciting programs that are happening at the library in the next month or so. On tomorrow, the 17th, we're having the age-friendly civic coffee hour, and this time we are discussing ways to prepare for upcoming winter months and how to remain physically active and socially engaged. This program will be interpreted into 3 languages. So we have Vietnamese, Somali, and Oromo, and it's going to be in person at the High Point Neighborhood House. We would love to see you, and we also are live streaming it, and I will drop the information on how to access that at the end. Today, we still are running our twice weekly silver art classes on Mondays at 1:30, Saturdays at 10:30 a.m. This month we have found sculptures, poetry, pastels, story time, sip and paints, and more. We'd love to have you join us, and I will also drop the information on that in the bottom as well, in the chat as well. And then lastly, on Tuesday, December 6th, we have a really exciting program called Preventing Medicare Fraud and Abuse. It is in partnership with Sheba, and it's a free hybrid presentation to look at common scams and how to avoid them. So if you want any information on any of these programs, you can always visit www.spl.org, or you can give us a call. Our number is 206-386-4636. And I will be dropping more information in the chat, but thank you and welcome everyone.
Wonderful. Thank you so much. It sounds like you guys have some wonderful stuff queued up to fill the space until PMA is back with new 2023 programming. I'd really encourage any of the folks that are attending today to check those out. They're wonderful resources for the community. Well, that's enough from Emily and I. I know the real reason everyone's here is to benefit from the expertise of today's presenter. Elizabeth Jennings is joining us from Stokes Lawrence Law. Welcome, Elizabeth. It's such a delight to see you again. You've been a long-time presenter of ours, and we're always delighted to bring you back.
I'm happy to be here, and thank you for the Seattle Public Library to host, and just hearing about some of the other programs that they provide. It's all kind of in the space that I work in, so I'm glad that People's Memorial and the library are trying to educate people on these issues. So I am here. Let me make sure I can share my screen. I'm here today to talk about estate planning. And myself, I'm an estate planning attorney. I also do work in estate administration when someone has passed away, as well as estate litigation. So when things kind of go wrong, there's conflict, or someone who does planning that doesn't really work out, or it's not done well, that's where I get called as well. So I always like to do these presentations and the people that attend them so that you have the tools to dig into these issues, to put a plan in place, to ask the right questions, and have these conversations with loved ones. So when we're talking about estate planning, I generally think of that in kind of three big categories. The most common that people think about with estate planning is planning for death, right? What happens when we pass away? How do we transfer our wealth? How do we provide for the people and organizations that we care for? And what are the documents that help us do that? But another component of estate planning that's really important that sometimes gets overlooked is planning for incapacity. So I will touch on, what happens if you are unable to make your own decisions, whether permanent or temporary. How do you put a plan in place for someone you know and trust to be able to step into your shoes? And then the kind of best part of estate planning is planning to live a long time, right? How do we pay for potentially increasing care needs? Medicaid planning sometimes is part of estate planning, financial planning, gifting. So I won't get into too much of that today, but that's kind of the fun part of my job of working with financial advisors and clients to kind of fill in those gaps. So I do want to start on this lovely fall or winter afternoon talking about planning for death and some of the common estate planning documents that you may already be familiar with, that you may already have, or those documents or planning that you should do, but you've been putting off for a while. So when it comes to planning for death and basic estate planning, it's really just a way that you can plan in advance how you want your wealth, whatever you accumulate during your lifetime, to pass to the people or organizations that you care about. As we'll talk about, there are some default rules, state by state, default rules in Washington if you don't do any planning. But oftentimes that one size fits all doesn't really fit everyone. So this is your opportunity to put down on paper who you want to provide for and how you want to provide for them if you're no longer here. So when I'm doing these presentations, I always invite you to think about, what do you own? And what's going to happen to that when you have passed away? My husband always says he hopes the last check he writes bounces, so there won't be anything left. But oftentimes there's something, right? Or it's very important for you to want to pass your wealth off to family members or to organizations. So first step I usually advise clients is think about what you own, what's actually in your estate. And that can fit into two different buckets. There's non-probate assets and there are probate assets. So non-probate assets are things that you own that already have a built-in mechanism for transferring that asset if you pass away. We'll talk about what some of those are. But there's also those assets that don't automatically have a beneficiary on them. Could be your house, could be bank accounts, different items that you own. Those are largely going to be governed by your will, or if you don't have a will, by state statute. So if you're taking this session to kind of think about what do I need to know, what do I need to think about, I want you to think about what you own and do you have any non-probate assets? That can be bank accounts or real estate that you opened as joint tenants with right of survivorship. That means if you co-own property with another person, whoever outlives the other will automatically get that property. You may have designated a pay on death beneficiary on an account. Very common for retirement accounts when you open your 401k or your IRA or whatever it may be, that you designated a beneficiary on those accounts. There's some other tools that you can pass assets at death without probate. Washington has a process called a transfer on death deed to transfer real estate at death. And then we'll also touch on trusts as a way to potentially avoid probate, which is not as horrible as some people make it sound. But if you're looking for a to-do list for yourself, I would say think about what you own, whether it's your house, financial accounts, your dog or cat, whatever it may be. And is there a way that you can ensure that that asset is going to transfer to someone else at death? If you set up these accounts a long time ago, especially as it gets cold outside in the winter months, if you want to curl up next to a fire, good activity to start checking these accounts. Who do I have as my beneficiary? Do I still want that person listed? And then update those accordingly. So that's one way to plan and to pass wealth. Another document I always like to mention is particularly helpful for spouses. So if you're not part of a couple, probably not going to be super helpful. But something to keep in mind is community property agreements or community property survivorship agreement. So Washington is a community property estate, which means the majority of what you accumulate while married is considered community property. Maybe gifts that you've received, inheritances you've received, things you owned prior to marriage, that may be separate property. But a community property agreement is essentially a contract between spouses, and it's a estate planning tool that they can use. And it really simplifies the process of transferring separate and community assets to the surviving spouse when one passes away. So it's essentially an agreement between them that says, when I pass away, I want everything I own to be considered community property. And I want my interest in community property to go to my spouse. So that's a really helpful tool if one spouse passes away to avoid the need for probate. It can simplify the process, but it's not always a good fit for everyone. As we'll talk about, there are some estate tax considerations. If it seems like one spouse may need to qualify for Medicaid or some government needs-based services in the future, it may not be a good fit. But I want you to remember community property agreements. That's something to ask your attorney about or think about if it's a good fit for you. So besides non-probate assets or community property agreement, The kind of big estate planning document that people always think about is a will, right? A last will and testament. And I hear a lot of misconceptions about what a will is, what's required. So I want you to kind of think about, do you have a will? Does it check all these boxes? And if not, what may you want to include in that document? So at the very basic level, pretty much anyone can make a will. It is any person of sound mind, any legal adult. And a will is a document that covers the disposition of your estate. It can cover everything you own. You can simply say, I give everything to my spouse, or you can parse out certain things. I give my house to this person. I give my antique lamp to this other person. So it really is something that can be customized for whatever your needs are. It does have to be in writing, especially in Washington. It does have to be signed by the testator, the person making the will, and it needs to be witnessed. The testator's signing needs to be witnessed by two disinterested individuals who will actually sign the will. And then ideally, they also sign a self-proving affidavit so that when you pass away, we don't have to go hunt down those two witnesses and double check with them that you had capacity when you signed your will. So some wills can be a couple pages long. Some can be dozens of pages long. It really is just a mechanism for you to spell out your wishes as far as what happens to your estate and who you want to handle that estate for you. So some kind of basic will content that you'll see in most wills, whether it's a form or something you work with your attorney with, it's going to identify who you are, and it's also going to identify your immediate family. Even if you don't want to give assent to your immediate family, it's often helpful for you to actually name them in the will itself so that someone can't come back later and say, well, they didn't name me, maybe they intentionally didn't provide for me. So naming your immediate family is one way to kind of prove that you have that testamentary capacity. You may also see in a lot of wills, particularly here in Washington, a paragraph about the disposition of personal property. So Washington has this great statute in our revised Code of Washington under Title 11 that provides you can keep a separate list of tangible personal property and who you want it to go to. So that's things like collectibles in your home, items in your home, things that you can kind of pick up and move around. Can't be cash, can't be real estate. But the law says if you reference in your will or estate planning documents that you may keep a separate list, then you can keep a separate list and add to it and change it as often as you like without having to go through all the same will formalities of two witnesses and signing. So that's helpful to look for, especially if you have a will right now. Do you have that paragraph? And are there certain things that you want to designate for particular people? You can add to that, update that. And then when it comes to passing over your wealth or your assets, you tend to see two different groups. One may be a list of specific bequests, and those are specific things that you identify that you want to give to specific people. It could be a dollar amount, right? I want to give $10,000 to my brother Robert. He's great. I want to give $5,000 to my brother Brian. I don't like him as much. You can also give specific items or real estate to specific people. Wills will also have or should have a rest, residue, or remainder clause. And that essentially says for everything else that I haven't specifically given to someone, here's what I want to happen to it. It can be everything to one person. It can be everything to a class of people, right? I want everything to be split equally amongst my grandchildren. or you can divide it up into percentages or shares. So really trying to cover anything that doesn't pass by a non-probate designation is going to be a catch-all for this rest, residue, and remainder clause. Your will should also contain a couple of other important paragraphs and things to make sure that it's going to be effective and helpful for planning. So in addition to what you want to happen to your assets, you should also designate someone who's in charge of making sure that your wishes are carried out. So that's designating a personal representative, also named an executor, or sometimes an administrator, right? It's the person or succession of individuals that you're saying, I want this person to have authority to settle my final affairs, right? Make sure my final bills are paid, make sure that my assets are distributed according to the provisions in my will. So always thinking about who do I trust in that role, who's willing to take on that role. I have a lot of clients that maybe did their wills decades ago, and the person they named as their executor is no longer someone in their life. So it's something, if you've already done this estate planning, dust off that will, see if the people that you've named, you're still comfortable with naming them in those roles. You typically also see that when you're naming an executor, that you're giving them non-intervention powers and waiving bond. So that's a way that you can tell a court, I trust this person. I want them to have full authority to stand in my shoes, to settle my estate without having to keep going back to court to get permission for certain activities. So that's one way. If your will does have to be probated, has to be administered in order to pass on your wealth, a way to make it a little bit more cost effective and efficient for that person you've named as your personal representative. You also, as the maker of a will, need to sign the will, and you should date the will, right? So oftentimes it's the most recent will that can control, because you may revoke all your prior wills whenever you make a new one. So important to sign and date, and to do that in front of two witnesses. Again, witnesses who aren't also the beneficiaries under your will. They can be neighbors, they can be friends. If you work with an estate planning attorney, it's often the people on their staff. But they're going to sign the will, right? That you intended this to be their will. It was actually you who signed it. They believe you have capacity and you weren't under any sort of duress. So really, really helpful to kind of follow these formalities, because without them, your will may not be effective. If you don't know who to trust in the role of personal representative or executor, I saw a question in the chat about potentially naming a commercial executor instead of a family member. So there are professional fiduciary organizations and companies, many in the Seattle area. Also, a lot of large banks may have their own kind of division to handle with wills and trusts, but you can name a professional. And I do think that's a good option for some people, right? If they don't necessarily trust their friends or family members, they don't have someone in mind that they want to name, or they simply don't want to put that responsibility on someone, particularly when it's a really tough time for them. So that's something to look at as well, right? Do you want to name a friend or family member, or do you want to name a professional who is not emotionally invested, who's not financially invested to settle your estate? They do charge. So it could be an hourly fee, it could be a percentage of the share of your estate, depending on the arrangement. So definitely something to look into and research. But if you're interested, I would say Google professional fiduciary and your zip code, and you'll probably find several organizations that take on that role. So as I mentioned, wills can be customized as much as possible. Those are kind of the basic things that you'll see in typical wills, but other wills may contain, what do you want to happen to your pet, right? Do you want to set up a trust or designate someone to care for your pet? Do you want to specify particular wishes about funeral or burial arrangements? Are there certain caveats that you want to put on certain gifting and alternate arrangements? And you'll often see some wills will have trusts. So a trust is a different estate planning device that can be used within a will. If it's within a will, it's called a testamentary trust, or it can be separate from a will. It can be its own standalone document. But at the very basic level, a trust is just an arrangement where you specify how you want distributions of your estate to happen. So if you just want to give to someone outright, that's great within a simple will. But if you want to set certain requirements or kind of dole out money at different points of time, a trust may be a good option for you. I also get lots of questions about trusts because I know Susie Orman is a big fan of them. She lives in California, and California has a notoriously difficult and expensive probate process, so trusts tend to be very important there. But for me, a trust doesn't necessarily fit everyone, but it's something to talk to an estate planning attorney about if you think it may be something you're interested in. So it can be a separate document, it can be part of your will, but it's just an arrangement where you designate someone who's going to hold on to or manage property or assets for the benefit of someone else. So it's typically a great solution if you have a minor beneficiary. Even if you have an 18-year-old, you may not want to give them a large share of the estate, not knowing if they're going to be responsible. It may be beneficial for beneficiaries that are incapacitated or receiving government benefits. It's a way for them to get the benefit of the gift that you're giving them, but someone else, a trustee, is going to manage that property for them. So really helpful tool, as I said, if you have a minor or an irresponsible beneficiary or a beneficiary that's receiving or you think is going to receive needs-based government benefits, this can be a really good tool to pass gifts to them. It can also be a helpful tool. A trust can be useful if you've got real estate in several different states, right? You may want to avoid having to do probate in several different states. A trust can be a good way to structure that. And some people are very private. So if your will is admitted to probate, that means it's filed with the court. It becomes a public record. So oftentimes you hear about celebrities, very famous people, wealthy people. They may not have a will. They may put everything into a trust so that it's not discoverable by the public at large. Trust can also be a good structure if you've got a large taxable estate. There are some ways that you can structure your estate planning to reduce or eliminate certain estate taxes. So a trust is one of those estate planning documents that I don't typically recommend that you go it alone or try to put it together yourself. It's definitely something that I recommend you work with an experienced estate planning attorney with. So as I mentioned, people tend to worry about estate taxes, or the news will sometimes call them death taxes. A couple of brief points I just want to make about that. So there is estate tax that gets imposed over certain exemption amounts. So right now in Washington, if I were to pass away tomorrow, the state of Washington doesn't start to collect tax on my estate unless it exceeds $2,193,000. At the federal level right now, The federal government doesn't collect estate tax unless my estate exceeds $12 million. Can tell you right now, not a problem for me. But it is a big problem for some people, especially if you own real estate in Seattle, right? The value's probably gone up. You've accumulated a lot of wealth, and it's possible that maybe your estate triggers one or both of these estate tax levels. It's important to keep in mind that you can give unlimited gifts to your spouse and to charities and to certain political organizations to avoid estate taxes. So there's some ways, again, you can work with a experienced estate planning attorney, with your financial advisor. How do we structure your estate to reduce those estate taxes if that's important to you? So some basic things to keep in mind about your will and your estate planning. My advice at this point is, if you've done this planning before, pull out those documents, take a look, make sure they still make sense for your life. If they don't, time to do some updates. If you don't have any of these, right, now is a good time to start thinking about what your wishes are to put that plan in place. I also recommend, I tell my clients, every year, every few years, anytime there's a big life event, a change, a marriage, a divorce, a birth, a death, good time to pull these documents out, check your beneficiary designations, make sure that they still accurately reflect your wishes. So all of that has to do with planning for death. But a big consideration is what happens during our lifetime if we become incapacitated or we have a disability where we're not able to fully make decisions for ourselves. So there's a whole level of estate planning that deals with that situation. So I'm going to talk briefly about financial powers of attorney, healthcare powers of attorney, and advanced directives. I think through the prior sessions, you probably already tackled some of these issues, so I won't go too far into them. But we'll dabble. Again, you'll start to get the vocabulary and know what questions to ask. So if you've done your estate planning and you have a will, great. But that will doesn't have any legal force and effect if you're still alive. So it's important to also have estate planning where you address periods where you are alive, but perhaps unable to manage your own affairs, make your own medical decisions, or make your own financial decisions. That can be a temporary incapacity, or it can be something that progresses. Typically we see, I have, a lot of clients that are working with their parents or their grandparents that maybe there's increasing complications with dementia or Alzheimer's, and it's more difficult for them to be able to pay their bills on time and things like that. So that's where a power of attorney can be a really helpful tool. And a durable power of attorney is another one of those important estate planning documents where you select who you want your agent to be. You essentially specify, I trust this person to stand in my shoes if I'm unable to handle my affairs myself. You can name one person, you can name two people to work together, you can name a professional fiduciary, or you can also name a succession of different people, right? If my first choice isn't available or willing, here's the next person I select and the person after that. You can make a power of attorney very broad, or you can make it really limited. So maybe you are going out of the country for a long, relaxing vacation, and you're in the process of selling your house. Maybe you do a very limited power of attorney who has the authority to finish that real estate transaction while you're gone. Powers of attorney are governed by state statute. So if you've got some time to kill, I recommend checking out the Revised Code of Washington, Title 11. Chapter 125. That has got everything you need to know about powers of attorney, the different authority you can grant, limits on that authority. Really helpful as you start to think about what you may want to put in a power of attorney. Good place to start if you're just getting familiar with these. You can name a spouse, a child who's a legal adult. You can name a family member, a friend, or a professional in that role as agent. And as I mentioned before, you can name as many people as you'd like in succession. So this is another one of those documents that if you've done it previously, and maybe it's been a few years or a few decades since you've looked at it, good time to pull out the power of attorney. Are those people you've named still in your life? Are they still able to act or willing to act? And do you have some alternatives in place? The danger is if you don't have any alternatives or you don't have a power of attorney, there's limited recourse available. So in Washington, if you don't have a power of attorney and you're unable to make your own healthcare decisions, we do have a statute that specifies who has priority to make decisions for you, right? Your spouse, your adult children, your parents, your siblings. When it comes to financial or property issues, there is no default. And so in that case, if it's critical, right, there may need to be a court action, a guardianship or a conservatorship, which can be long, can be expensive, can be a hassle. And you, if you're the person incapacitated, don't get to necessarily make the decision of who you want to make these choices for you going forward. So important document to think about and add to your estate planning kind of package. You also want to think about when do you want that power of attorney to be effective? And this is particularly for financial matters. Do you want it to be effective immediately so that as soon as you sign it, your agent has the authority to step into your shoes, whether or not you are incapacitated? This may be a good option for spouses that already have a lot of joint accounts, things like that. It's also something that may be helpful if someone is starting to experience memory issues or they're doing all right now, but they may be progressively getting worse. May be helpful to make it immediate so that you don't have to jump through the hoops of getting a physician to certify that someone is no longer able to manage their own affairs. So that's the alternate power of attorney, right? That it's called a springing power of attorney. And that just means that you sign the document today, but your agent won't have any authority to act unless one or more physicians are willing to sign on the dotted line saying this person is medically incapacitated and needs someone else to take over their affairs. So things to think about and look for if you've already done your power of attorney planning. Powers of attorney do need to be in writing, and your signature either needs to be notarized or done in front of two witnesses. I do recommend notarization. If the power of attorney ever has to be used for a real estate transaction, a lot of title companies want to see that that signature was notarized. There are some basic power of attorney authority that you'll see in statute, but there are also extra powers that you can grant your agent under a power of attorney, but they have to be specifically spelled out in that document. So for example, if you want your agent under a power of attorney to have the authority to add pay on death beneficiaries to your account, they need to specifically have that authority spelled out in the document. If you want your agent to make gifts out of your assets, that has to be specified in the document itself. So powers of attorney can be super broad or super limited depending on your comfort level. Okay, Let's see. So I mentioned that there's two kind of scenarios where a power of attorney may come into play. It can be healthcare decisions. It can be financial decisions. You can name the same person in both roles, or you can name different individuals. So if you have a power of attorney that deals with finances or property, some of those typical powers include paying your bills, right? Being able to write checks out of your bank account or open and close bank accounts, paying your bills, filing taxes on your behalf. Again, this is important if there's a time where you're just not able to manage these things yourself. You've already designated someone you trust who can help you with that, or step into your shoes and start managing the finances on your behalf. It's a lot of power, a lot of responsibility, but again, can be really helpful if someone no longer has capacity to do these things themselves. You may also want a power of attorney for healthcare. So some attorneys will do, or some, forms will be a joint financial and healthcare power of attorney. I tend to do them two separate ones because who I trust personally with my financial decisions is a little bit different than who I want making medical decisions for me. But a power of attorney for healthcare essentially is who should be able to give informed consent and direct your medical treatment if you're unable to express your wishes yourself. As I mentioned, if you don't have a healthcare power of attorney, Washington does have a statute that lists an order of priority for who can give informed consent if you are unable to do so yourself. So especially if you want to depart from that default list that Washington provides, good time to do a power of attorney for healthcare. If you've ever gone into the hospital for surgery, they'll probably ask you, do you have a healthcare power of attorney? If you don't, they'll probably have you fill out a short little form that they have. But really important to have, again, who can be called if you're unable to make your own decisions. Something that if you do prepare either now or you've already done it, good to give it a copy to your primary care physician. Ask that it be added to your medical records if there's ever an emergency. So to add to your to-do list for a rainy day, if you already have powers of attorney, pull them out, take a look at them, make sure you're still comfortable with the individuals that you've selected, any backups that you may want to add, and that you're comfortable with the authority that you've given them, and comfortable about when that document will become effective. Powers of attorney are also, I would say, more common that you can find some forms on the internet for free. I think at Seattle University Law School has some very basic healthcare and financial powers of attorney. You can take a look at those. But you can also know that they can be really broad. So another one of those documents that can be customized to your comfort level. If you don't already have them, start thinking about the decisions you may want to make and who you may want to give that authority to. I think People's Memorial has probably hosted a more in-depth discussion of advanced directives and healthcare directives. But it goes along with your healthcare power of attorney, right? If you can't, in the moment, express your wishes in the event of a terminal illness or incapacity, what do you want, right? What kind of medical interventions do you want? What do you give a consent for in advance? So we are, by statute, you can look up kind of a very basic healthcare directive in Washington that really is triggered in instances where you are in a permanent coma or you are permanently incapacitated, and what kind of life-prolonging interventions do you want? So you'll see in the statute that there's decisions about artificial respiration, artificial hydration, really having those conversations with yourself, with your family members, with your care providers. what are your wishes for end-of-life care? And even though you think everyone around you knows what your wishes are, it's really helpful to put them down on paper. It does take some burden off of your healthcare agent or your family members to make these really life-altering decisions. If they can point to something you've prepared and your written wishes, that can make it a little bit easier for them. You may also hear about post forms or do not resuscitate orders. Those are typically something that you would prepare with your physician as you age, if you've got any medical diagnoses, right? Do you want certain interventions? If like 911 is called, should they do CPR? Should they try to give you certain treatment? So all of these are tough conversations to have, but again, really helpful to have clarified in the case of an emergency and to help your designated agent carry out the wishes that you have and have expressed. So if you don't have a living will or an advance directive, now is a good time to think about these things. If you've done one before, again, good time to check, does this still accurately reflect my wishes? And if you've done one, especially with the assistance of an attorney, does anyone know about it? Is it part of your medical records? I also had a couple clients that say, oh, we printed extra copies and put them in our glove compartment, right? If there was a car accident or an emergency. Do your loved ones know what your wishes are? Even though these are tough conversations to have, if the people that you've named as your healthcare agent, your financial power of attorney, your executor, if those people know what your wishes are in advance and know that they may be called on in an emergency, that can go a lot more smoothly. So it's important to have these tough conversations now. So even though a little bit of a downer thinking about these horrible scenarios, there is a lot of planning you can do. So as I mentioned, have those tough conversations. I know Thanksgiving is coming up, the holiday, the new year. Maybe after you've had your turkey and mashed potatoes, have those conversations with your loved ones, right? Have they done their own estate planning? Typically, I get a lot of clients, or when I'm doing presentations, I'm getting individuals who have maybe done this planning before. And I always tell them, call your friend, call your children, call those individuals that maybe haven't thought about these things and have them really think about doing them now. I recently met with a group of friends that are all recently married, all recently had minor children, had children or babies that were born, and they started thinking about these issues, right? Who do they want to designate as guardian for their children? What are their concerns? So starting these conversations soon and having those open, free exchange of information now can be really beneficial down the road. Also helpful to-do list thing you can do right now, even after you log off, is jot down a list of your resources. What do you own? Not just what shows up on your tax return, but it could be your house, your financial assets, your personal property, the things you care about. Do those have beneficiaries designated? Are they current? And if they don't have designated beneficiaries, or you can't designate a beneficiary, do you have a will or a trust or some other mechanism to make sure that those assets are adequately dealt with? If you've done estate planning before, you can pat yourself on the back. You are well ahead of a lot of individuals, but pull out those documents, make sure that they're still current. If you do need to make changes, so especially if you're wanting to make changes to your will, it is not effective to just cross stuff out and handwrite changes in. Every change in your will needs to be witnessed by 2 witnesses in order to be effective. So I always caution individuals, be careful about making your own changes informally. It can actually have the opposite effect, that you've eliminated or terminated some of those provisions. So be very careful if you're making these changes, and make sure that you're following all the will formalities and formalities to do new powers of attorney. If you've done all this planning, know where those documents are. My great uncle, when I was younger, he said he had done all of this planning, but no one could find his will when he passed away. So it's important, when you've done this planning, to share that information with the people you trust and the people you've named as fiduciaries, whether it's healthcare power of attorney, financial power of attorney, personal representative of your will. If something happens to you, do they know where to actually find these documents? It's totally up to you if you want to share full copies of them now while you're alive, or you want to tell them, hey, if something happens to me, here's where I keep these important documents, or here's my attorney, contact them if something happens. But they have no use if no one can find them. So have those conversations with the people you've named. Let them know that you've named them, so it's not a surprise, and let them know what to do if something happens, where to find those documents, or what they should know. While there is a lot of planning that you can do independently, I also recommend consult with the experts, right? Especially as your net worth increases, you have more assets, or you have more people who depend on you, whether it's minors or family members. It's really important to make sure that the plans you put in place are actually going to be effective to be carried out, and that you've maximized kind of what you want to accomplish. So whether it's working with an estate planning attorney, frequently I'll work with someone's financial advisor or their CPA, right, to get an idea of what plans are already in place. Making sure that you've got all this information in front of you as you talk to an expert or you talk to an attorney to try to do this planning. And just sitting through this presentation, you're already starting ahead of the game. You know the lingo, you know what questions to ask and things to think about. So good step to get started. Organize your thoughts, organize your finances, and then have these really in-depth conversations about what's a good plan for you and what you want to accomplish. So I know we've got some questions in the chat box. I will try to answer as many as I can. Inevitably, there is a really specific question, and I will not be giving kind of direct legal advice today, but I'm happy to answer general questions, and then feel free to reach out. Myself, my contact information is here. Feel free to Google or Yelp estate planning attorneys or elder law attorneys. There's some great resources, I'm sure, in the Seattle Public Library as well, to dig into these topics. Great resources online. So the more you know, the better prepared you can be to make these decisions.
Thank you so
Okay.
much. Ooh, so much good stuff. We've got some great questions in here. Are you ready?
I will try.
Okay, the first one's actually from me, because this is, you know, as many times as I've sat in on your presentation, you mentioned something today that I don't think you normally do. You were talking about setting up a trust as a really good planning tool for folks that are affected by needs-based assistance. Would you talk about why sometimes maybe when we think we're doing a good thing to help someone who certainly got the financial need, we might actually impact someone negatively by not doing this upfront planning? Because I think folks would benefit from hearing more about that.
Yeah, that's a great question. Because, right, we think about someone who maybe needs extra help, extra support, or maybe it's a loved one or spouse who does have medical challenges and you think is going to need long-term care that can be very expensive. If you want to give them money or assets outright, that's going to count against them when it comes to needs-based benefits. So for example, Medicaid is a needs-based benefit to cover some long-term care costs like memory care or an assisted living facility or an adult family home. But if they suddenly get an influx of an inheritance, they may be kicked off that benefit because now they can pay for it themselves. But there is some planning you can do, like a special needs trust, in order to give that person the benefit of the money, but put it in a structure that it doesn't count against them for the government benefits they may already be receiving or you think they may be receiving in the future. So that's another good example, a good time to really talk with an experienced attorney about that. Make sure that the structure is really accomplishing what you want. And like you said, not maybe hurting that beneficiary in the process.
Yeah, we've certainly had some cases where people were trying to do the right thing, but they made a mess financially by maybe increasing someone's tax liability on accident. Also, that can be a big challenge.
Yeah.
Okay, so the first question here is with respect to unlimited gifts for spouses, does that trigger gift reporting for being over $15,000 a year?
Not for your spouse. But again, there are these kind of exempt individuals that or charities that you can gift to. But that's also a really good point about these exemption limits I mentioned earlier. So especially at the federal exemption amount, that's kind of a lifetime gifting bar. And so typically we're gifting the most amounts at death, and that's where estate or gift tax are triggered. But if you've made a lot of significant gifts exceeding the gift reporting threshold, that all kind of gets tallied up. So again, really important to work with a CPA, an estate planning attorney, figure out the best way to gift if you want to kind of minimize those taxes that may have to be paid out of your estate.
Yeah, and I was glad that you mentioned about how folks tend to get real specific with their questions. I'll make sure to include the information for the King County Bar Association, and I think Seattle has their own as well. Those folks do free legal clinics, and in that half hour, you can determine whether or not you should retain the services of an attorney or a financial planner. But I'll make sure that everybody has access to that in the follow-up email with the recording. And do you think you could share your slides with folks?
Yeah, I'll send those over to you. But as you mentioned, the King County Bar Association does great neighborhood clinics and estate planning clinics. Good first step. They may be able to help you start to finish, or they may say, hey, this is a little bit more complex. Here's some resources you should check out.
Yeah, I can't imagine I'm the only person in this webinar thinking, ooh, I can't spend a lot of money gambling on whether or not I'm going to need that attorney. So this is a great first step.
Yeah.
So here's a pretty basic question. Can your executor and a beneficiary be the same person? Like if you make your spouse your executor, is there any issue with them receiving?
That's perfectly fine, right? And it's very common, right? You want to provide for someone that you love and trust, and you also trust them to carry out your affairs. So very common to, especially if you're married, maybe gift everything to your spouse and also named your spouse as the executor of your estate or the trustee of the trust in which they're going to be a beneficiary of.
Yeah, makes sense. What about your designated powers of attorney? Should it be one person, or should one be healthcare, one be finances? Is there any issue with there being overlap there?
Not an issue, but it's something to really think about, right? Do you want to name the same people? Again, totally fine to name your spouse or your children in those same roles. But I also think, some people may have differences of, I have a family member who works in the medical field. I feel like they're maybe a little bit more equipped to help with the medical component. That person who I love, also, I don't think is great with managing finances. So I'm thinking about who's going to be best in this particular role. You're fine to name the same people. I also have questions about, should I name two co-attorneys, in fact, or two co-agents?
Are there people you shouldn't name, or like anything like that, like limits on who you can pick for these different roles?
So I always caution, if you want to name more than one person, so co-agents, are they going to be able to work well together and communicate well together? And do you anticipate conflict, right? What happens if those two people you name have totally different opinions about what should happen? So whenever you're naming more than one person to act together, I would say put some thought into that, and then you may want to work on language so that, is there kind of a tiebreaker? Is there a scenario? What happens if there's a conflict? Important to think about that, but if they work well together, and you're confident on that, and they're the people you want to name, there's no problem naming two individuals.
That makes sense. It sounds like an awful lot of responsibility. One of the attendees pointed out that, like, in Canada, if you designate someone as a POA, you can't pay them for their services. What about in the US? Is there like a way to compensate people for all the responsibility you're giving them?
Yes. So in Washington, by statute, your designated agent under a power of attorney can request and receive reasonable compensation. Where it's tricky is the law doesn't really specify what is reasonable compensation, right? Is that their regular rate, whatever they do as a day job? Is it minimum wage, right? It starts to get a little bit complicated. So if you're ever in that role that you're acting as someone's agent, I tell my clients, keep track of your time, right? Keep time records, what you did, how long it took. Or if you know you've been named in this role, have a conversation with the person who named you. Are they comfortable with you getting paid for that role? And what do they think is reasonable as far as an hourly rate or compensation?
Oh, that makes a lot of sense. Let's see. Gosh, there's just so much good stuff on here. So if you decide that you want to work with an estate attorney, what should people expect in terms of how much to pay to, like, pull all those essentials together? Your will, your durable POA, your advance directive. What is that going to cost somebody? I know it's probably pretty variable, right?
It is, right? You'll probably be able to find attorneys that will do like a flat fee for certain types of documents. So I would say if you have a non-taxable estate, pretty simple estate, those are a great fit. They could be anything. I mean, don't hold me to this, but I would say you may see ballparks of maybe $1,000 for powers of attorney, will, healthcare directive, kind of the package. I've also seen upwards of $2,000 or $3,000 or $5,000 for those estate planning packages. There are also,
you have like kind of a complicated estate, maybe.
Yeah, and that's where the more complicated the estate or the larger the estate, that's where you may end up paying more, right? Because some of these tools to reduce or eliminate estate taxes or these gifting strategies, they're not, again, one size fits all, and a simple form is not going to accomplish what your goal is. And so I would say a lot of estate planning attorneys will charge by the hour. And so if you are meeting with one of those attorneys, again, very typical, if you go into those meetings knowing what you have, knowing if you've designated a beneficiary on certain accounts, having a general idea of what you want to accomplish, that's going to be a lot more efficient. I have some clients who show up and they don't know what they want, or they don't have a basic understanding of some of these documents. And that takes a little bit more work and hand-holding and tends to be a little bit more expensive. So you've already done a great first step, learning the very basics and kind of being able to hit the ground running if you do want to meet with an attorney to do some of this planning.
Yeah, that's a good point. For folks that are ready to take that step, they've done their homework. Do you have any suggestions or for maybe like green flags when you're shopping for an attorney, or maybe some red flags, some stuff to watch out for?
Yeah, I would say in my experience, almost every law office will say we do wills and trusts. But I would say look for an attorney that is what they do, or that is an essential part of their practice. They don't do criminal, personal injury, estate planning, family law, kind of. That can be great to have that general knowledge. But again, as your estate, if you do have significant assets, you really want someone who's experienced in what you're trying to accomplish in estate planning. Referrals are great, right? A good opener to have these conversations with friends and loved ones and family members. Who did they work with? They have a good experience. I think word of mouth is one of the great best opportunities, and word gets around if someone hasn't done a great job or is difficult to work with.
That makes sense. For folks that are ready to take the leap on their own, do you have any suggestions for resources to do your own will and testament?
Yeah, there are some good resources online. I think I mentioned the Seattle University Law School. I know they've got some good powers of attorney, kind of good basic documents. You know, there's options like LegalZoom online for a small fee. You know, I would say just proceed with caution, right? Do your research. Again, it's not always one size fits all, but good place to start. And then as life changes, you want to name different people or your wealth increases, then it may be worthwhile to take that document, see if it still fits, and have an attorney take a look at it.
That makes a lot of sense. Okay, so gosh, there's just so many good questions in here. Okay, so let's say you're already ahead of the game. You've done some of this planning. It's time to make some changes, maybe throw in a codicil or two. You know, do you still need to go through that formal process of having witnesses, watch your signing? Do you still need to get those changes notarized?
Yeah, so again, especially for the will, any changes still need to follow the same formalities as making that original will. So sign and date in front of two witnesses who are doing a witness attestation. So again, those handwritten changes aren't effective. Sometimes it's easier just to do a whole new will, or to do a codicil, which is essentially like an amendment to a will. Still has to follow the same will formalities, but maybe simple if you're just changing a few names or one or two paragraphs.
Okay, you ready for a real estate question?
I'll see what I can.
Okay, so if someone has a minor child that they want to be beneficiary on a home that they're still paying off, is that possible? How does that work?
So important to know about minors. If someone is under the age of 18, they can't legally own or inherit property. So it may be that you want to think about a trust for that minor, designate a guardian or conservator for that minor, right? Who should hold on to or manage that property until they reach a certain age. And you can really get creative with these trusts, right? You can provide, they should be able to live in that property as long as they want. Or if there's money in the trust, maybe you give them 20% when they hit 18 and 30% when they hit 25. You can kind of dole out money or assets as you'd like to kind of make sure that maybe an 18-year-old doesn't get everything all at once. But again, anytime that there's a minor, important to think about who do you want to manage that property for them until they're legally or developmentally able to handle that property on their own.
Makes sense. Okay, so an interesting asset question. You mentioned the side list, you know, to designate specific property to specific individuals, but you mentioned specifically not to include cash in there. What about antique or collectible bills and coins, you know, the kind that aren't still circulating? Is that like still cash, or is that like collectibles? How does that work?
Oh, that's a good question. It's been a while since I've looked at the statute, but I do believe it does address coins that are more collectible than currency. Can't give like cold hard cash or a bank account, but I do believe it does provide some specificity about that scenario. So I'd have to double check. I did cite to that statute in my presentation, so I encourage you to read it yourself, and I will go brush up myself to know the answer to that question a little bit better.
Ooh,
yeah.
Okay, well, we're coming up on 2:15 here. Are you okay to still tackle a few more questions, or you got to run off somewhere?
I got about 10 more minutes, so happy to tackle more.
Okay, let's do this. Okay. Okay, so if someone is interested in setting up a trust, how can they find an advisor for a qualified domestic trust or a credit shelter trust?
Those are trust scenarios that I highly recommend consulting with an attorney about. Again, lots of different trust scenarios, lots of different tax structures. So a credit shelter trust or any sort of trust where taxes come into play, talk with an attorney. You may also want to look, you were talking about what to look for. The bigger your estate, you may also want to look for an attorney who, in addition to a law degree, has their LLM in tax. So that's an additional degree. It's kind of like a master's attorney that deals with tax issues as well. So again, an experienced estate planning attorney, and then if taxes are a big consideration, you may want to look for that LLM designation when you're looking at attorneys.
Okay, let's see. Oh, more questions keep coming in and they're all so interesting. Okay, so if someone is named as your power of attorney for your estate, for your finances, do they also have to handle the disposition of your remains?
That is a good question and something that People's Memorial can really help with. So, you can provide in a power of attorney if you want to specifically give someone authority that extends beyond your death, because a power of attorney usually has zero effect once you've passed away. But if you do want to extend their authority to deal with the disposition of your remains or funeral or burial arrangements, that needs to be specified. And I believe, you can correct me if I'm wrong, that if you are a member of People's Memorial, they also have their own forms that you can specify exactly who you want to be in charge of that and what your wishes are as far as your remains.
Yeah, no, absolutely. So those forms are actually available to everybody for free on our website. We have a disposition authorization where you specifically spell out what you want done with your body, and then also a designated agent form, which is like a power of attorney, but for your death. Since people commonly say, oh yeah, my POA is going to handle everything. And like Elizabeth said, no, the POA ends when you do. You got to have a special person designated to run point on that. So very important. Don't overlook that, especially if there's someone in particular you do or don't want handling that care. Here's a question. I'm not sure what it's referring to. Maybe you'll know what this means. Where is LTC you own be listed?
I'm not too sure, because LTC in a lot of my world relates to long-term care. So if that person wants to specify, well, I'll follow up.
Okay. All right, no problem. Okay. Ooh, interesting. What about collectibles that you might have that are no longer legal to sell, like ivory?
That's a great question as well. And I haven't had that specific scenario before, but I have had some gifting that can be a little bit more complicated or regulated, like firearms, or yes, things that are maybe a little bit unusual, a little bit more of a case-by-case basis. That's what I would say. It depends what it is and who you're giving it to and what issues may pop up.
That's interesting. And it kind of, one of the things people ask us a lot about People's Memorial actually is about like inheriting or acquiring human remains, like bones, where it used to not be a very controlled thing, but it's very illegal to sell human bones specifically, but sometimes people have things in the family. So this seems like a thing you might want to consult directly with an attorney about, maybe do a little bit of research.
Agreed. Have those interesting conversations, and you can get into some specifics that may help.
Ooh, here's one that comes up quite a bit. Someone's curious, if they want to leave their money to their sister, but if something happens to her, she wants the sister's daughter to inherit, not that money to go to the sister's husband. How can you direct the pathway of inheritance?
That's a really good reason to do some of this estate planning. So the best case scenario, or kind of the planning that you would do with a good estate planning attorney, is they're going to go through contingency plans, right? So it may be, if this person predeceases you, then what do you want to happen to their share? Do you want it to go to their children, or do you want it to go to someone else, or do you want it to be donated to charity? So you can build in lots of different scenarios. I can't remember if it was in one of these sessions or another attorney I was talking to, but this person mentioned, they bring up the exploding turkey scenario, right? If all of your closest loved ones are with you on Thanksgiving and the turkey explodes, then what? Is there a person or a charity or someone that you want to gift to? You can build in all those alternate scenarios into your estate planning, so that you don't necessarily have to update your documents every time something happens. So that's where estate planning documents can start to get a little bit beefier, lots of different scenarios to work with.
And I think, aside from the comedy of an exploding turkey, I think this makes a lot of sense if you have everything designated for your spouse, because there's a pretty good likelihood that your spouse is going to be with you when you pass. And if they go too, what's the game plan? Maybe not too bad of an idea to put some thought into that. Yeah. Okay, let's do one more question. Oh, so LTC is long-term care. Is planning for that part of estate planning?
Yes, so good. Glad we were on the same page. Yeah, so planning for long-term care is something we typically do as part of estate planning, also looking at your finances. And so we'll work with a lot of financial advisors who our clients are already connected with. You know, looking at, are there assets available to plan for long-term care? Do we maybe want to put in our estate planning something like a special needs trust in order to help a loved one pay for long-term care or qualify for government benefits? That is part of the big picture. So if long-term care and planning for the kind of expensive side of paying for long-term care and increased needs and healthcare issues, definitely something to work with an attorney about, and especially an experienced estate planning attorney or elder law attorney. One of those monikers, really helpful. Again, big picture, looking at your finances and what your concerns are.
That makes a lot of sense. Okay, well, here we are at 2:20. We still have questions, but I'm thinking maybe I can send them over to you, and maybe we can work on coming up with some answers to include in the follow-up email. And then, you know, if you have additional questions, you know, of course, we encourage you to reach out to Elizabeth. Her contact information is on the screen there, and she's at Stokes Lawrence. I'm also going to make sure that you have the information for some of our local bar associations who can provide you with some free legal advice to get you started in your process. And of course, you can reach out to us at PMA, but you know, the questions on this stuff tend to be a little on the specific side, and it's a little outside of the scope of our training at PMA, but we're happy to do what we can to help. And, you know, we roll deep with some really smart people. So we're happy to connect you up with another organization that can help you get the information you need.
And I would also say, as someone had asked about, you know, how do you find a good attorney to work with? Give them a call. I know I typically, and a lot of other attorneys I know, will talk to you for 20-30 minutes, get a sense. You can kind of interview them, ask questions, and call a few people. Make sure you find someone you're comfortable with, and that can handle your particular concerns.
Yeah, that makes a lot of sense. Well, before we close out for today, Emily, did you have anything you'd like to say? Looks like you are muted, friend.
I don't specifically, but I did drop a survey in the chat. If you guys could all fill it out, that would be wonderful. And then I believe that Beverly is also including that in the email that she sends out to you all. But thank you so much for coming. We always appreciate all the questions and you all engaging. And we are really excited that you are all here. So thank you very much.
Yeah, we know this might be a little bit of a tough sell when the weather's so nice. So thank you for joining us, and keep your eyes peeled for that follow-up email with a number of resources that we've mentioned today, the recording and all of that. And thank you so much for joining us. It's been another great Ducks in a Row series with you all. Bye, everyone.
Bye.